Hello and welcome to BYJU'S Exam Prep IAS. Before we start with our today's analysis, we have an announcement. Chetan sir has recorded a video which is of places in news. This is uploaded on our YouTube channel. Please do like, watch the video and share it with your fellow aspirants. Let's get started and look into the first article. The first article says, no one can insist that judge disclose reason for recusal, says the Delhi High Court. What is this article speaking about? The article is speaking about recusal of the judges. What do we understand by recusal of a judge? Let's say, for example, in one of the cases, the judge may feel that he may have an inherent bias towards one of the litigants, or the party may feel that the judge will have a bias towards one of the litigants. In that case, the judge removing himself from a particular proceeding is what is called as recusal of a judge. When there is a conflict of interest, a judge can withdraw from hearing a case to prevent creating a perception that she carried a bias while deciding the case, which is called as recusal of a judge. How does this work? There are two ways of looking at it. The judge in the previous instance would have represented the litigant. The judge himself or herself might feel that if she takes part in the proceedings, it may lead to a biased judgment. So the judge on the own may recuse from that particular proceedings, or the party in this particular case, that is the litigant, may also ask or request the court of law to recuse that particular judge because they believe that the judgment being passed by that judge may be in terms of a biased nature, which is where you have the judge who can recuse himself on his own, or you might also have a situation where the lawyers or the party may bring it before the court of law and ultimately the judge may recuse himself. So basically, if a conflict of interest exists, the judge may recuse herself on her own initiative. In addition, any party in a case may take a motion to require the judge to recuse herself from hearing the case. What are the instances or the circumstances where the judge usually recuses himself or herself? The first is the bias of prejudice. What do we understand by this? If the judge has acted or taken a stand or publicly spoken in a way that prevents him or her from treating the party in a fair and an impartial manner, that is called as bias of prejudice. In such a case, the judge may recuse himself or herself. Then we have the judge who might have appeared for one of the litigants at some stage. What do we mean by it? Let's say, for example, there is a case which comes to the court of law. In court of law, there will be two parties. One will be the petitioner, the other will be the respondent. So what would happen? In the earlier instances, if the judge was working as an advocate, he might have represented one of the parties in this particular petition, and as a result, the judge may feel that in case he passes a judgment, it may look in a biased nature, so the judge himself recuses from the proceeding. Why? Because previously he had represented one of the parties. Then the judge may have a financial interest in the litigation. What do we mean by it? Let's say, for example, there is one of the companies. This company approaches the court of law. This judge may have shares in the company, or he has some financial advantages from the company. In such a case, a judge who has a financial interest in the litigation may back off from this proceeding. Why? Because he has some share in the company, and if he conducts such a proceedings, he may give a biased judgment. So in such a case, the judge may recuse himself or herself. Or the family member's economic interest in the case, let's say, for example, the spouse or the children or the immediate relatives, is any of these people are present in that particular case, the judge can once again recuse from that particular position. So these are some of the ways where a judge himself or herself can recuse from that particular issue. Now the question is, can a judge refuse to recuse? Yes, there have been instances like that. Once a request is made for the recusal, the decision to recuse or not ultimately rests with the judge. We have one of the examples from the year 2019. This is in reference to Justice Arun Mishra. What happened? Justice Arun Mishra had controversially refused to recuse himself from the Constitution bench, which was set up to re-examine the judgment that he had delivered previously. Why did Justice Arun Mishra not recuse himself? That is because he basically felt that this would give rise to forum shopping. What is forum shopping? Forum shopping is a process where a litigant usually goes in front of that particular bench or that particular judge so that this will enable him to get a favorable judgment. So in this particular case, Justice Arun Mishra says that if he recuses, it may give light to forum shopping where the litigant is choosing his or her own judge so that that particular litigation goes in favor of one of the parties. So in 2019, Justice Arun Mishra, even though he was requested, he did not recuse from one of the proceedings. Then we also have Justice U. Lalit, who went ahead with the recusal. This is in reference to Ayodhya Ram Janmabhoomi case, where he, being a lawyer in the previous instance, had represented this particular party. As a result, he went on to recuse. So basically, this is the discretion given to the judges. The judges may recuse themselves or they may not recuse themselves as well. This ultimately means that there are no explicit guidelines controlling the procedure. Individual judges are frequently left to record grounds for the recusal. So they may record the recusal details, why they are withdrawing from that particular case, or they need not have to give as well. That is primarily because there is no clear-cut guidelines when it comes to this particular issue. Some judges disclose the reason in open court and some judges do not disclose the reasons, and as a result it can lead to opaqueness when it comes to the recusal process. Also remember, when we speak about the recusal, if most of the judges started recusing themselves because one of the litigants or the lawyers want them to recuse, this ultimately means that they can lead to travesty of justice. How? Whenever we have the judges who are participating in the Supreme Court or in the High Court, they take the oath. The oath is to promise to perform their duties and to deliver justice without fear or favor, affection or ill will. Now, if one of the parties who wants to enter into that forum shopping believes that this particular judge may not give the judgment in their favor, they may come up with some cases against the judge. They may say that this judge could actually give a judgment in favor of the other litigant. So if the judge recuses, this might lead to forum shopping. So an unwanted recusal denigrates the principle of rule of law, it impairs the judicial fairness, and it allows the parties to cherry pick a particular bench of their choice. So this should be ultimately eliminated. So what we require is one of the process. So what should be done? As of now, there are no formal rules governing the recusal, although several Supreme Court judgments have dealt with this particular issue. The first judgment is in reference to Ranjit Thakur versus the Union of India, where the Supreme Court held that the test of the likelihood of bias is the reasonableness of the apprehension in the mind of the party. Then we have Supreme Court Advocates on Record Association versus the Union of India, where Justice Chalameshwar said, where a judge has a pecuniary interest, no further inquiry needs to be done, but in other cases such an inquiry is required and relevant test is to be conducted. What does this mean? It means that if the judge has a financial advantage, in such a case he in all likelihood can recuse. In any other cases, this has to be investigated as to why the judge is recusing or the lawyers or the litigants is asking for the recusal. And finally, in National Judicial Appointments Commission case, we have Justice Kurian Joseph and Justice Madun Lakur, who also said that if judges are recusing, they have to give valid reasons for the same to build in transparency and also help frame rules to govern this entire process. So as of now, this process does not have any rules as such. It does not have any conventions as such. It does not have any statutory provisions. So what is the way forward? The bar councils and other associations are vested with enough power. So they have to ensure that judges give the reasons for recusal as a matter of requirement. It is the duty of the bar council to ensure that the client knows why the judge has been recused from their specific matter, and at the same time, going forward, what we require is a statutory provision which will clearly give guidelines as to how and when the judges can recuse themselves. So the need of the hour is to come up with the statutory guidelines for the recusal proceedings. It is this that we have to understand in reference to this article. Now let's look into the next article. This article says the food vaccine as right, more so for the TB patients. The article here is speaking about tuberculosis. Before we understand what this article is trying to convey, let's understand some basic information with respect to the tuberculosis. Tuberculosis is caused by bacteria, Mycobacterium tuberculosis, that most often affects the lungs. How does it spread? When we speak about tuberculosis, TB bacteria are spread from the air from one person to another person. Let's assume for a moment that a person is suffering from tuberculosis. He is infected by the bacteria Mycobacterium tuberculosis. So if this particular person whose lungs are already infected, if he starts coughing, if he starts speaking, if he starts singing, in such a case, people in and around who breathe this bacteria can become infected. If we have to look into the statistics, a total of 1.5 million people died from tuberculosis in 2020. Worldwide, TB is the 13th leading cause of death and the second leading infectious killer after COVID-19. In 2020, an estimated 10 million people fell ill with tuberculosis worldwide, 5.6 million men, 3.3 million women, and 1.1 million children. TB is present in all countries and age groups, but TB is curable and preventable. In 2020, 1.1 million children fell ill with TB globally. Child and adolescent TB is often overlooked by health providers and can be difficult to diagnose and treat. In 2020, the 30 high TB burden countries accounted for 86% of new TB cases. 8 countries account for two-thirds of the total, with India leading the count. So what are the symptoms of tuberculosis? If a person is coughing for 3 to 4 weeks, that can be a probable symptom for tuberculosis. Coughing up blood or mucus, chest pain or pain with breathing or coughing, unintentional weight loss, fatigue, fever, night sweats, chills, loss of appetite are some of the symptoms of tuberculosis. What is this article speaking about? This article currently goes on to say that there were no drugs for TB till the discovery of streptomycin in 1943. With improved wages, better living standards, and the accompanying higher purchasing power for food, the TB mortality rate came down from 300 people per 1 lakh population to 60 in England and Wales. What do we understand by this? The article currently goes on to say the idea of coming up with a drug for the tuberculosis came only in the year 1943 with the presence of the streptomycin. Before that, we did not have any drug or the tablets for the tuberculosis. But what was the way of mitigating this impact? One was to provide nutritious food to the people in that particular jurisdiction. If that particular person is provided enough calorie intake, if he is provided nutritional food to a larger extent, it will help in mitigating the impact of the tuberculosis. The nutrition of the individual is the most vital factor in the prevention in tuberculosis disease. 90% of the Indians exposed to TB remain inactive if their nutritional status and thereby the immune system is good. When the infected person is immunocompromised, TB as a disease manifests itself in 10% of the infected. So what do we understand? Once again, this clearly points out that if you consider the data and statistics and if you juxtapose two kind of people, one with enough calorie intake, with enough amount of food to be eaten by the people, in such a case, what you will have is the impact of tuberculosis felt on such a person will be comparatively less. If they are not provided with nutritional food, in such a case, tuberculosis may exaggerate as well. So what are we speaking about? We are speaking about tuberculosis. Tuberculosis, yes, will have number of medicines. Tuberculosis also has drugs as well. Added to these drugs, if people are given enough nutritional support, that will help in cutting down the impact of tuberculosis. There were a number of studies conducted in different parts of the country. One in Bilaspur in Chhattisgarh. Then we also have Professor Anurag Bhargava who comes up with his own study, and we also have 2019 Global TB report as well. So all these reports and studies ultimately say that if that particular individual suffering from tuberculosis is provided with enough nutritional food, in such cases the impact of tuberculosis is completely comparatively less. In 2014, research led by Dr. Anurag Bhargava showed that undernutrition in the adult population was the major driver of India's TB epidemic. So, poor young people, people who are below the poverty line, if they are not provided with enough nutritious food, such people may suffer from tuberculosis and it may impact their health as well. Added to this, the government also faces other issues as well. When it comes to tuberculosis, the tuberculosis treatment has to be done on a daily basis. However, when it comes to tuberculosis in the rural areas, number of people take the medications in an alternative basis. They do not keep a check of it, and ultimately people are the major sufferers. There is also poor monitoring of the fact whether the patient is regularly taking the doses or not. This is also often misreported as well. Ideally, they should be taking it on a daily basis or as prescribed. Whether they are taking it or not is also not accountable as well. Actual number of cases reported in the National Register for the tuberculosis is far less than the number of people who are actually affected. Hence, people do not know that they have tuberculosis, and since this is contagious, it goes on spreading as well. So what we also have to do is we have to create an awareness in such people who do not know the symptoms of tuberculosis. So the author in this article goes on to say, apart from the drugs which is administered to the patients, what we have to provide is nutritional support to these people, and at the same time these individuals will have to be monitored and awareness will have to be created so that we can bring an end to this particular issue of tuberculosis, since intake of adequate food is one of the important issues concerning the tuberculosis. Food itself can act as a vaccine is a metaphor the author brings into picture. It is this that we have to understand in reference to this article. Now let's look into the next article. This article says take two. What does this article speak about? The article here is speaking about the new guidelines initiated by the University Grants Commission in reference to the dual degree academic program. What do we understand by dual degree academic program? Most of us, when we started studying, we always wanted to venture into different fields. Let's say, for example, a person studying in commerce might also wanted to study political science as well. Let's say a person studying in political science wanted to take up another commerce degree as well. Earlier, this person was not able to study, but now with the latest notification issued by the University Grant Commission, a person would be able to study simultaneously. One, when it comes to the undergraduate degree; second, when it comes to the post graduation. But this is not applicable for the PhD courses. So what would happen? A person pursuing one of the degrees would also be able to engage himself in another degree simultaneously. So what he would be able to pursue is two degrees at the same time. How does this work? The UGC has proposed a three-way choice where a combination of offline classes can be taken up. What do we mean by it? When we speak about degrees, this can be awarded to a person. Dual degrees can be awarded. The first one is this particular person goes to the physical classes. Let's say, for example, he goes to the physical classes in the morning, but at the same time he can also go to the physical classes in the evening as well. Such classes should be in such a way that there should be no clashes between the classes, and ultimately he would be able to go to the classes physically offline mode simultaneously. So the first option given by the UGC is that an individual wanting to pursue dual degree academic program would be able to attend offline or the physical classes simultaneously, but only thing that he has to look into is that this particular class should not be happening at the same time. That's the first option. The second option is an offline with the distance mode. What do we understand by this? A person who wants to have a dual degree academic program, if he has to get two degrees simultaneously, he can take up the second option as well, where in one of the option he has to continue the physical classes, which is the offline classes. He has to go to the class, and in an other mode, instead of going to the physical class, he can also choose the distance education mode as well. And the third is where distance or online only modes of dual programs can also be chosen. if the person is choosing the distance education mode, then higher education institute should be recognized by the law. So if there is a statutory provision, only if that particular university is being recognized, only if that university recognized by the government is giving the distance mode education, only then it is acceptable, says this notification. So basically there are three modes: physical and physical, physical and distance, distance and online. This can be taken up for the dual degree process. So open distance learning and online mode courses should be pursued only in the higher education institutions recognized by the statutory bodies. Why did the UGC come up with such a notification? That is to eliminate all the dubious institutes and players who are present in the online education segment. However, when it comes to the rules, when it comes to the regulations, the UGC has also given permission to the universities where they can come up with their own rules and regulations as to how they would be able to provide dual degree academic program. So basically, if we are speaking about the objective of the dual degree academic program, there will be no hard separation between the arts and the science background. This will eliminate the hierarchies, and ultimately this whole compartmentalization will be completely removed, and enabling an individual to study one or more specialized areas of interest at a deeper level will also be provided with this particular program. However, there is one issue in this particular guideline. Let's say there is an individual who is very brilliant, he is intelligent. This individual who is brilliant or intelligent would be able to take up one of the courses, let's say technical course, and this individual, because he is brainy, because he is a nerd type, because he is actually good with the studies, would also be able to get another degree, let's say an arts degree. Since he is taking up the arts degree as well, he is snatching away the seat of an other individual. So an individual who wants to only study arts, his seat will be taken up by this brilliant person. Or let's assume this particular individual is also economically sound, he happens to be a rich person. Even in such a case, this individual can take up one course and another course, and such an individual who wants to take up only one course, his seat will be taken away. In fact, the UGC's Farkan Kamar committee a decade ago recommended dual program with a second degree in open or distance mode had ruled out offering simultaneous degree courses under the regular mode, as it may create logistic, administrative and academic problems. This is the issue with respect to the dual degree academic program, which the UGC will have to relook into, is what is this article all about. Now let's look into the next article. This article says Egypt to import wheat from India. We have discussed similar such articles in the past as well. Because of the Ukraine and the Russian crisis, many countries are not able to import different types of commodities. One such commodity that we have currently is wheat. Egypt was one of the beneficiary which was importing a lot of wheat from Ukraine and Russia. Because of the crisis that is unfolding in Ukraine and Russia, they are now not able to import wheat, and as a result, what is Egypt looking at? Egypt is looking at India, and India is planning to export wheat to Egypt. Most of its imports are from Ukraine and Russia. Nearly 80% of the Egypt's wheat imports, estimated to be around $2 billion in 2021, were from Russia and Ukraine. And in the wake of trade disruptions caused due to Ukraine conflict, Egypt is exploring other sources, which is from India. Officials from the Agriculture Quarantine and Pacific Analysis of Egypt examining the processing units, port facilities and farms in various states in India and agreed to import wheat from India. India is undertaking measures to ensure that the best quality of wheat will be exported to Egypt. India is looking to export about 1 million tons of wheat to Egypt. India aims to export about 10 to 11 million tons of wheat in financial year due to increasing global demand post the Russian invasion of Ukraine. India is having trade talks with various other countries that look to import wheat from the country. It is this that we have to understand in reference to this article. Now let's look into the mains practice questions. The lack of an objective standard in recusal of judges may cause uncertainty and judicial backlogs. Analyze. Without addressing undernutrition, the goals of reducing the incidence of TB and mortality in India cannot be reached. Examine. So please write all your answers on the comment section. Peer review. Do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.